Hello and welcome. This is the third in this YouTube series regarding restitution and what happens after you're released from the Federal Bureau of Prisons. Well, to start, your restitution payment, be it in actual dollars or percentages, was already negotiated when you did your plea agreement with the judge or with the prosecutor. But that being said, it gets to be alarming when you see, because when I too had a felony in 2006, and while my medical license, I had to return it. I got it back luckily in 2010. But none of this really was around for me. But it's alarming to see that 25% of your paycheck can be deducted right off the top. And this is collected after taxes. So that this is not before you even looked at your covered essential expenses. This is a substantial amount of money that can deeply impact your financial situation. This is crazy. And so for those of you then who rely on Social Security, that 25% is even worse. It makes it more difficult to hit your day-to-day needs. So it's crucial to realize these percentages before you even get to either self-surrendering, excuse me, before you even get to the plea deal, while you still have your attorney, because while when I read about this from other attorneys, they encourage aiming for a 15%. I'm You want to go as low as you can. If you can afford more, great. But you want that 10% meaningful relief, for you want a 10% on the judge's records for what you would owe for restitution, or $25 a month or $35 a month. And then if your ability to pay increases, then great. But 10%, I mean, that can pretty much kill some people. Don't underestimate how much even a small amount can change and improve your quality of life. Every dollar matters, especially when you're first getting out. In the past, and I qualify, well, not for this part. Many individuals and I know people who stopped sending payments after finishing their probation due to lack of oversight. However, you can't do that. Failing to pay your restitution can lead to serious consequences, making your life significantly more difficult. Worst yet, the financial litigation unit will require you to complete a detailed legal form outlining your expenses. Every month, I had to send my probation officer a list of my expenses and what I made, what I spent. Every month, I faxed it in. And so then what happens, the financial litigation unit would send this stuff to me from Virginia. And I had to fill it out then after I was off supervised release. You don't want to lie to them. I mean, because if you fill this in and then lie and send it in wrong, that's it's like it's sending in a illegal, sending in tax forms that you lied on. That's a legal document. You don't want to walk down that road. So supervised release, communication with your probation officer is key. Remember, restitution is mandatory. The probation officer is not going to send you back to prison, but don't go ahead and start and then cry no money. Don't spend, and not paying off your restitution, but go ahead and lease expensive cars and expensive houses. They're just going to make your life difficult. This litigation union, if you stop making payments 20 years after your halfway house release date, be aware that their government's financial litigation union, they call it FLU, has powerful tools. They can impose liens in your home, and in many cases, these liens will be out there throughout your financial history. I mean, they follow you. Furthermore, they have the authority to garnish your wages and Social Security income and place liens on other property and assets. They can take stock in the money coming in or the stocks themselves, money from bonds, trusts, Social Security, retirement benefits, and your children's college funds. Remember that all these assets are at risk due to your restitution. Have this conversation first with your attorney Second, with your family. The Financial Litigation Union requires defendants to fill out these affidavits every few years. Do not lie. There's something called community property. There's a community property state. There are several community property states. This kicks in when you're married at the time of the charge. The situation can affect your inheritance and influence assets of your spouse and children. This more applies up here. It can impact stocks, bonds, trusts, and Social Security retirement benefits of them also, and their college accounts. And so it puts at risk, if you're married at the time, now it puts your spouse's income and money at risk. So you want to stay informed and take proactive steps to protect what matters most. You don't want to go ahead. It doesn't do any good to get divorced after you've been charged, because this kicks in if you were married uh, during at the time of the indictment, or at the time of when you committed the crime. And so, for more information on that, go over here. And this is, what states are community property, and I think I have equal ownership. These are the states. So you can look and see right here. And see if I can go back into where I was. Oh, I can't. So I did this wrong. That's great. Okay. Another reason to have great communication with probation officers. I took this initiative to resolve the matter on my own, as I explained in the former YouTube, that I had my own probation officers. I had to send them every month. I had a form I had to fill and fax into them all of the money that I made and what I had to spend, that I couldn't expend. I couldn't, afford the amount of restitution I was asked to do. And so the probation officer requested a reduction in my monthly payment to $25 a month from my judge. The judge agreed, and I put it in my bank and arranged for automatic bill pay in my bank for the next 99 years. So I just wouldn't forget. I just wasn't taking any chances. Now, I know people that went ahead and after they were off probation, they stopped paying, but I just don't know that I want to take that chance. Federal Criminal Justice Act, the courts will not appoint counsel to help you lower your restitution payments. You need to have good communication with your probation officer. 18 U.S.C. 3613, civil remedies for satisfaction of an unpaid fine. The liability to pay restitution shall terminate 20 years after the judgment, release from prison, that you're ordered to pay restitution. In the event of death of the person ordered to pay restitution, your estate will be held responsible. 3613A, effective default. If the court finds that the defendant has defaulted on the restitution payment, it may evoke probation or supervised release per Section 3565. Additionally, the court can modify the terms of probation or supervised release, resentence the defendant under 3614, hold the defendant in contempt, issue a restraining order or injunction, order the sale of the defendant's property, accept a performance bond, set or revise a payment schedule, or take other necessary actions to enforce compliance or fine or restitution order. In deciding what action to take, the court shall consider the defendant's employment status, earning potential, financial resources, the intentionality in failing to comply with the fine or restitution order, and any other factors that may influence the defendant's ability to comply with the order of a fine or restitution. You need to have a good relationship with your probation officer. You don't want to have, an antagonistic relationship. I've never heard, and when I talk to attorneys, I've never heard of anyone, and they've never heard of anyone getting placed back in prison for failure to pay. And that's what this resentencing upon failure to pay a fine. No one has ever heard of anyone being placed back in prison for that reason. I hope you found this helpful. All these links on my website go to the codes in question for you to read on your own, and I hope you have a good day.